Under what circumstances and under whose consent can a critically ill patient be allowed to die with dignity? Should, for example, a terminally ill patient be given the right to decide if the process of their death can be speeded up when there is no hope for their survival? It's not that there isn't past precedent in this. In a landmark judgment in 2011, the Supreme Court ruled that passive euthanasia, and we'll explain what that means in a while, can be allowed in some circumstances. They were looking at the case of Aruna Schonbag, who has been in a comatose state since she was brutally attacked and raped in 1973. Now, after the Supreme Court took up the petition of Common Cause, an NGO, it has decided that the entire issue of euthanasia and whether anyone has the right to terminate the life of critically ill patients needs to be decided by a constitution bench of the Supreme Court. Our second debate this evening: who has the right to decide when a life should be terminated to maintain the dignity of the patient? Joining us, Prashant Bhushan, senior advocate in the Supreme Court, someone who argued this particular case on behalf of Common Cause. Dr. Samir Kaul, senior oncologist, thanks so very much for being with us. Father Dominic Emmanuel, director of the Delhi Catholic Archdiocese. Thank you all very much for being with us. Mr. Bhushan, let me come to you first. Going through what the order today of the Supreme Court was, from a legal standpoint, does it question what happened in the Aruna Schonbag case, when it actually says quite clearly that some of the points which had been raised in that particular judgment were questionable? So it says the Aruna Schonbag judgment, which upholds the validity of passive euthanasia and lays down an elaborate procedure for executing the same, is based on the wrong premise that the Constitution bench in the earlier case, the Gyankor case, had upheld the same. If that is the case, what happens to the Aruna Schonbag case, sir, where euthanasia in certain circumstances had been legalized?
Well, I think the reference of this case to the Constitution bench is only for the purpose of settling it by a larger bench once and for all, and not just the question of passive euthanasia. Perhaps the question of active euthanasia would also need to be settled by the Constitution bench. To my mind, actually, this issue of passive euthanasia is not an issue which can admit to much argument. The issue is very simple. Every individual has a fundamental right not to be forced to take intrusive medical treatment. I have a right not to subject myself either to a ventilator or any other form of intrusive medical treatment if I choose not to do so. Nobody can force me to do so against my will.
No, but sir, a patient who is put on a ventilator often is put on the ventilator without their consent. A person with breathing distress doesn't decide for themselves when they go on ventilator. It's decided by their family or friends or whoever it may be.
No, so that's what I am saying. So the first proposition is that if I am conscious and in a position to take a decision for myself, and if I choose not to be put on a ventilator, or if I choose not to take any intrusive medical intervention, then I have a fundamental right to do so. Second proposition is that if I have expressed my will, this is what living will is. If I have expressed my will when I enter a hospital, that should I be now in a position where I go in a coma or become unconscious, and therefore am not in a position to express myself, and am in a state where I cannot be revived in any, there is no reasonable hope or reasonable chance of my becoming well again.
Yes.
And if my life can only be prolonged by intrusive medical treatment, then I do not want to be put under that intrusive medical treatment.
Dr.
That's what living will is called.
Father, go ahead.
So therefore,
may I just intervene? Actually, what Prashant is saying is quite right, but where Prashant is not able to make a distinction, that one is the not extraordinary intervention, medical intervention. That is one thing. But to say euthanasia, which is mercy killing, and assisted killing, there is a big difference between those two. And the church itself,
that's also active euthanasia.
Yeah, so there is a big difference. What you're saying, the first part is fine, that there need not be.
I'm talking about passive euthanasia.
Passive euthanasia you call it, but no, what we are saying is that it is not, you don't have to take extraordinary means.
Let me interrupt, because he raises an important point and it's central to the argument. I think we need a doctor to actually go through this. Now, the passive euthanasia refers to the process, and correct me if I'm wrong, when, for example, medical treatment to a patient in distress or patient who is very, very unwell, is comatose, is brought down. For example, ventilator function is brought down, medical assistance is brought down. They are kept for humane reasons on food intravenously, but ultimately the patient dies. Whereas active euthanasia is when a lethal injection or something like that is used. But the argument which is whether one is necessarily more humane than the other. At the end of the day, you are ending the life of a patient.
I think it's a very side argument to the main issue in terms of, and if Prashant Bhushan will understand it probably more, and I'm sure you will too, it's a matter of omission and commission. Active euthanasia just means, and if I were to quote the Hippocratic Oath, which is 4th century BC, I'm just trying to
go ahead.
To present to you both sides of the thing. Provide no medicine which will take away life is what the Hippocratic Oath said that I will never do.
Right.
But if I discontinue, if I have a detached view to continuing medical care that already exists on a patient in terms of a feeding tube or a ventilator down one's throat, or maybe an IV drip to maintain nutrition, and I seem to have a detached view and I discontinue it.
Yes.
One is, I haven't administered anything, I haven't directly caused the death.
You've cut down on it.
But it is the motive that is important, and I think both of you will agree to that. But even if I am doing it by omission,
I don't know if he agrees to it.
He would, because it is, if I am omitting something that I should have done, knowing fully well that if I switched it off, the motive is the same. And therefore, a lot of people in this world,
your motive is to cut down
because
on pain,
I know
right?
that if I cut, my motives could be anything.
To end
if
suffering.
I do that.
That's your motive as a doctor.
Suffering. My motive is to know that I will detach this tube and cause immediate death of this patient. So I know, even if I am not administering a medication, but I'm putting a stop to what is already going on and maintaining life, I am causing the same thing by an act of omission. And therefore, the motive is the same. So it really doesn't make a difference. So it's such a
doctor,
small
bottom
argument.
line, what you're trying to say is that it's not something as doctors you should be doing.
If you really ask me, and I see death at very close quarters,
that's why I asked
being an oncologist, how many times do I actually face this situation where I really need to rack my brain and my mind and my heart, if you may, to decide on whether I should follow one principle or the other? The truth of the matter is 2% of the times. 2% of the times does it really become so difficult to decide.
Doctor, you see hundreds
as to
of
what
patients.
I should.
2% of the time is
really small. No, it's small.
But how do you confront these cases? You would see hundreds of patients every few days.
There is another overplay to this, and that is this country. We live in that part of the world which has different sensibilities, different mental.
You don't want to take. So you, as a doctor, have a problem in taking that decision.
Of course, I have a problem. Okay. There are no direct guidelines. Like in the West, there is something called as an advanced medical directive.
No, I know that, and that's what the Supreme Court will decide. Constitution bench. I'll come to you next, Father. Prashant had a point. Mr. Bhushan, go ahead.
You see, when a patient is saying that, look, I don't want to be put on a ventilator, please don't put me on a ventilator, it's not the volition of the doctor then that is happening, it's the volition of the patient. Thereafter, in this situation, if the doctor says, no, though you don't want to be put on a ventilator, I am forcing the ventilator on you because I need to prolong your life.
You know, Prashant,
that is clearly illegal. That comes to amounts to illegal confinement under our criminal law. That amounts to assault and battery under our criminal law. No doctor has any right or the permission to involuntarily, against the patient's will, forcibly put him on a ventilator and thereafter extract money from his family when he does not want to do so.
This is assuming, sir, this is assuming that the patient has been admitted to the hospital in a state when he or she can decide whether they want to go under the ventilator. What about those patients, a large majority, where a person may already be comatose?
Something else.
So they can't,
that's what I'm saying.
Just a second. So they can't decide, can they?
There are three situations.
Okay.
The first is when a patient is in a conscious state and is in a position to express himself that he does not wish to have intrusive medical treatment. That is his absolute right. Second situation is when a patient has become unconscious and therefore is unable to express himself, but he has in advance given a living will that if he were to be in that state, he would not like to be put on this life support system, and therefore the doctor should not do that. That's living will. And the third is when the patient has not given a living will, as in the Aruna Shanbag case, and his guardian or the person who is regarded to be his guardian then decides that, well, in this situation there is no point in prolonging his life and continuing him in this agonizing state of affairs, continuing him in this pain, etc.
is wrong.
And therefore, please discontinue this medical treatment.
Okay, the doctor had a
These are all three cases of passive euthanasia.
No, but may I inform you that a situation wherein an Indian patient in an Indian hospital in this part of the world where we are trying to make a law, and the Supreme Court is currently deliberating, you know, the bigger bench will deliberate and give us guidelines. Hardly ever is practically there a situation where a voluntary patient walks up or asks for this choice to be exercised. Most of the times, overridingly, most of the times, it is the family having to decide, or the doctors having to decide, or both of them having to decide.
This is the third option which Mr. Bhushan is speaking about. Ultimately, sir, that will, or even if there is the lack of a will, is not the issue if the family ultimately decides for a patient who is in distress or is comatose, right? So you, in other words, you say euthanasia should be allowed.
You're talking, asking me?
I'm asking you, sir.
Yes. I feel that passive euthanasia must definitely be allowed. Even active euthanasia, in my view, if a patient is in a position where he is in such unbearable pain, he may not be in a situation where it's just a question of removal of his life support system or not putting him on a life support system. Suppose he is in a state of cancer and is in unbearable pain, and the medical opinion is that he is not likely to recover from that cancer and he will continue to be, or his pain is going to increase. In that situation, in my view, the patient should have a right to say that, look, I want my life to be ended by lethal injection.
It's a medical fact. Just a medical fact. Only 1/3 of the patients, and that's what the a global survey said, ask for euthanasia for pain control. It's other things more often. That was the experience in the United States of America.
Also, it's a very slippery slope argument that unbearable pain. What is the threshold of each one's pain, for one thing? Secondly, with medical advances now, can you really say that unbearable pain is the cause at all for killing someone? No. Even self-assisted, even the first case he was mentioning, that somebody asked you not to be put on ventilator. I mean, that's almost saying that, yes, I am allowed to commit suicide. That I am not undergoing the. Yes, when there is a case of extraordinary, out of the way.
No, but that's what he's talking about.
No, that's not extraordinary. Ventilator these days is a very common thing.
Okay.
Yeah. And with these medical advances these days, a lot of medical assistance can be given to patients.
I think it's extraordinary burden.
extraordinary financial burden as well.
About extraordinary or burden is something that would be considered, right by most people on both sides of the spectrum.
Even by the church, yes.
Absolutely.
Yeah.
Look, it's a fundamental issue. It's so very difficult. There are so many issues over here. There are issues of faith. There are issues of medicine. There are issues of the law.
No, it's not merely
of the
issue
Constitution,
of faith. It is the
of
issue.
the IPC.
No, it is
all
the
of
issue
this
of
has to
life.
be decided. All of this has to be decided.
I have to say,
by
Father,
just a moment, Doctor. I am completely out of time. We could debate this endlessly. I mean, it's gone on for such a long time. It comes up now at a constitution bench. It's gone on in this country for so many years. Will there finally be a decision, one way or the other, on what has to happen? I'd like to thank all of you for joining me this evening. It's time now for us to take this short break.